The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Welcome to the Supreme Court of Pennsylvania, sitting in this historic courtroom in downtown Harrisburg. We welcome all who are here to argue today in this historic courtroom. Just one detail is all of these murals were created by Violet Oakley in the 30s as part of the Works Project Administration. So these are historic, and this is considered one of the most beautiful courtrooms in the nation. So we welcome all here who are here to argue or to observe the court in action. And good morning, Mr. Minner. Good morning, Ms. Pizzozo. And good morning, everyone. You will be called to argue before us. You know, we don't have any time limits, and I think I will signal when I think we have heard enough of your argument. We'd like you to be concise and hit the major points of your arguments. You'll find that the justices are fully cognizant of the facts and the law in your arguments, and we have the benefits of your briefs, the opinions below, and in several of the cases, a number of amicus briefs to help us guide us in this in our decision here. This court was first founded in 1722 by the Constitution of 1722 and called the Supreme Court of Pennsylvania, but we hearken directly back to William Penn's Provincial Court, which was founded in 1684. So this court has been sitting continuously for 330 years, and it is the oldest Supreme Court in the nation. So we welcome all of you. And with that, Mr. Minner, could you call the first case?
Zauflik versus Pennsbury School District, Mr. Thomas Kline, Mr. Stephen Kozin.
Good morning, Mr. Kline.
Good morning.
This particular case involves the statutory cap on damages that are recoverable against a governmental agency found at 42 Pennsylvania's Consolidated Statutes 8553. And under that provision, the damages resulting from an action or a transaction against a municipality arising against a local agency are capped at $500,000 in the aggregate. In this particular case, a school bus driver applied the accelerator instead of the brake on a school bus, which then ran onto a sidewalk and ran over a 17-year-old student, Ashley Zauflik, causing catastrophic injuries to Miss Zauflik. At the trial, Pennsbury admitted liability for Zauflik's injury. The case went to a jury trial for damages and resulted in a verdict of over $14 million for past and future medical expenses and non-economic damages. Pennsbury raised the issue of the statutory cap on the damages, and the trial court molded the verdict to $500,000 plus delayed damages. The Commonwealth Court affirmed on the basis that the cap's been in effect for 34 years and that stare decisis doctrine applies to this cap. Zauflik's attorneys are the appellants here. They raised various policy questions and constitutional challenges to the cap. So if you could please introduce yourself, Mr. Kline, and you may begin.
I will, Mr. Chief Justice, thank you very much. I will speak into the microphone.
Okay, that'll help.
Thank you. As someone who's been at the bar for a very long time and having argued before this court on other occasions, I might say I've never been in this courtroom, and it is truly inspirational. I haven't argued in this courtroom, I should say. With that in mind, may it please the court. This court accepted aliquotter to consider 5 separate challenges to the Political Subdivision Tort Claims Act, which in this case resulted in a reduction of a $14 million jury verdict, not challenged on any basis of excessiveness, to $500,000. There are 5 separate constitutional challenges, 3 of which have never been heard before this court before. Article 1, Section 6, trial by jury. where a $14 million jury verdict, not challenged as excessive, was cut by 97%. Article 1, Section 26, the no discrimination section of the Declaration of Rights of the Constitution. Here we have a classic case of discrimination based upon the identity of a tortfeasor, and also no important governmental interest in justifying at a minimum here the taking of $11 million of insurance coverage, which applies to this case since that money has been spent in insurance premiums. And third, never heard before this court previously, Article 5, Section 1, a judicial powers challenge, where a statute resulted in a near 97% reduction, i.e. a remittitor. And I might add a remittitor which the trial judge himself said was unjust and unfair, and where he had, as I see it, the legislature holding the pen requiring him to do the remittitor. Interestingly, and this court knows well and has written recently in the Robinson case relating to the Declaration of Rights, Article 1 of the Pennsylvania Constitution, there are 3 separate challenges here which we have based upon Article 1, trial by jury, Section 6, open courts, Section 11, and the no discrimination, Section 26. I might add, while it is loosely said in many of the briefs that this has all been heard before and stare decisis applies, quite to the contrary. Even on the equal protection grounds, previously in the Smith case in 1986, the only equal protection challenge was an Article 3 challenge, Article 3, Section 32, the so-called no special laws provision. This court has never looked at equal protection, either in the face of an $11 million insurance policy paid already by a school district, nor, generally speaking, an Article 1 challenge, which deals with the fact here that there is pure, raw discrimination against a person who is injured based upon the status of the tortfeasor itself. There are 2 things which were previously decided in Smith and in the Carroll case, with which this court is well familiar, and that is the open courts part of it, which I'm prepared to discuss, which was frankly wrongly decided, a provision which says that of our Constitution, Article 1, Section 11, which says every person shall have a remedy for every injury, and which was correctly decided way long ago in a case called 13th and 15th Street Railways. I guess there was a 13th and 15th Street Railway at the time, where this court said a limitation of recovery to a sum less than the actual damage is palpably in conflict with right to remedy by due course of law.
Mr. Kline, can I ask you why you're on the open courts provision of the Constitution?
Sure.
Ask you what you take from the second sentence of that constitutional provision, which says suits may be brought against the Commonwealth in such manner, in such courts, and in such cases as the legislature may by law direct.
Yes, Justice Saylor, I've given it a lot of consideration, as you might expect. Number one, that applies to the Commonwealth, and we're not here to decide the Commonwealth today.
You're differentiating because what your argument then is that that applies purely to the sovereign and not to political subdivisions of the sovereign. Is that correct?
Having pored over this, yes, that's correct. In fact, if I might add, Article 1, Section 26 draws a distinction and says and talks about no discrimination by Commonwealth and its political subdivisions. This section, Article 1, Section 11, and the dissents pointed out in Carroll and Smith, clearly applies to the Commonwealth, it says, suits brought against the Commonwealth in such manner. The language of the Constitution says it. The Constitution says it in another place. And in Ayala and Brown, decided by this court, Justice Saylor, on the same day in 1973, the court said we cannot, on the same basis, abrogate sovereign immunity because the Constitution says something different about the Commonwealth. And so if you read those two cases, it's clear that what we have here is a complete distinction constitutionally and, by the way, statutorily. Statutes 8522 and 8553 dealing with the Commonwealth, the $500,000 cap and the immunities, deal with it differently. In the Commonwealth statute, it says the Commonwealth hereby waives. So there's many differences. And to suggest that this provision, the second sentence, encompasses the first sentence of Article 1, Section 11, I believe is just plain wrong.
As to political subdivisions.
As to political subdivisions, yes. Again, we're not here to discuss the Commonwealth. I could wax and wane about it, but that's really not what's before this court here. And also, this section, Justice Saylor, is procedural in nature. It doesn't attempt to take substantive rights. It couldn't possibly in the first sentence. And by the way, the title of this section is separated by a semicolon, meaning, in my view, two separate thoughts. And then in the first sentence, have all courts open, every man, meaning every person, have a remedy, justice administered without denial or delay. And then the second sentence must be just procedural. It does reserve to the Commonwealth the right to dictate the manner and the courts and the cases. It doesn't say, and the limitations on rights to recovery.
One final question, I don't want to monopolize this, but some courts, would you say rightly or wrongly, have read that second sentence as the constitutional underpinning for governmental immunity?
Yes, incorrectly. I might add, of interest, the two cases which decided this issue are, of course, the Smith and the Carroll case. The Smith case was, this Carroll case was much narrower. It only dealt with open courts. Of interest to me, as someone who clerked on this court for Justice Pomeroy in that era, was that in that court in the 80s, when Smith and Carroll were decided, 11 different justices decided those two cases. Only 3 decided the two cases. 1, Justice Nix, for constitutionality, 1, Justice Larson, against, and interestingly, Justice Flaherty joining the dissent of Justice Larson in Carroll and writing the majority opinion, stating what Your Honor just said to me was the underpinnings in his majority opinion in Smith. The jurisprudence is hardly overwhelming and hardly convincing, at least to this student of this court.
Is your position they can't put a cap at all?
The court, Justice Aiken, I believe, does not need to reach that in this case today. But if you ask me my opinion, I believe that is correct. That a cap, a limitation on damages to 0, is in conflict clearly with these various provisions. Well, starting with, I'm sorry.
If they put a cap of $100 million on it, is that unconstitutional?
Well, to someone who got a justified verdict of $100,001, yes, in theory. Here's the problem. The problem is the one section which I didn't get out in my early recitation here, which is Article 3, Section 18, says in plain, clear, unequivocal language, but for workers' comp cases, but for cases in workers' compensation, in no other cases shall the General Assembly limit the amount to be recovered for injuries resulting in death or for injuries. Now, the Smith case, Justice Flaherty decided that section, with a divided court I might add, decided that section didn't mean what it says. I would suggest to the court that that is wrong and that the dissents were correct, including Justice Kaufman, who in Smith said that there is no basis in law or logic to read this any other way but for what it says. And it says that there shall not be any limitation on the amount to be recovered for injuries. My word, our Constitution says no caps. What was not accepted out were the political subdivisions.
Nothing's accepted out there, is it?
Nothing. That's correct.
Well, what about the Commonwealth as defendant?
What about the Commonwealth?
They're accepted out by a different provision.
Well, we don't have the Commonwealth here today.
I know, but just conceptually, if it says no one is accepted out and somewhere else it says, well, the Commonwealth is accepted out, no one doesn't mean no one.
I believe, Justice Aiken, in the cases as they've developed, especially the admonition of the Ayala Court, which is just a dramatic, powerful case, and the companion cases that follow for regarding the Commonwealth, I believe set a significant precedent in this court and in this Commonwealth for the fact that we are a no-cap state. The Constitution says so, but we're not here to decide the Commonwealth today.
Mr. Kline, putting aside the dichotomy between the sovereign and political subdivisions, if the Commonwealth can bar a suit, prohibit a lawsuit against the sovereign, are you saying that if they allow a lawsuit, they can't control the amount of the damages, so it's all or nothing? My syllogy is, if they can bar a suit in the first instance,
Yes.
if they allow a suit, why can't they set the confines of that lawsuit under our state constitution?
The way I view it is that the Commonwealth cannot bar a lawsuit. That the second sentence, again, the second sentence applies to the
Commonwealth for anything, anytime. There's no sovereign immunity in Pennsylvania.
Yes, that's correct, and there's a case that says it. There's a series of cases, Brown and Melee, and there's a third case, which was a cleanup case, which all of which said exactly that. The Brown 73, Melee 78, and Lyles, the name escaped me for the moment, case in '86. The problem came in when the legislature tried to fix it. And again, we're not dealing with the Commonwealth, and I do believe that it's a different argument for a different day, perhaps under different facts. Here, what I have is proof that in the face of Ayala, a case which said there shall be no sovereign immunity, it is abolished as a concept with any vitality in this Commonwealth forevermore. I have a bona fide jury verdict of $14 million, which is not contested as being excessive, and it's reduced by 97%, which is tantamount, I think anyone would agree, to an immunity.
Mr. Kline, let me, in furtherance of questions being asked to you, I studied the case hard, and I think if I was writing on a blank slate, I might arrive at your conclusions. How do you get around the Smith case with not? And I have to go back. I jotted down your various justices, but the reality is that Part 1 of Justice Flaherty's opinion in Smith got 5 votes, and it's the one that Part 1 is what you're directly confronting, in that he took Article 1, Section 11, both sentences, and Article 3, Section 18, put them in historical context, and came to the conclusion that the legislature had the right to pass the Political Subdivision Tort Claims Act, and that act in terms would bar or would allow the statutory cap you confront today. And so my question is, given Smith as a majority expression of, I believe, 5 justices of this court, one Justice McDermott, I think, is missing, but I assume joined the majority. how do you get around stare decisis, which binds us even if we think it's wrong?
Well, there's a law in this Commonwealth that deals with, first of all, with stare decisis straight on. Ayala is a good starting point. I'll get to Smith. The orderly development of the law, has to be responsive. It is not a vehicle for perpetuating error. And my favorite in Ayala, if I might take the indulgence, is stare decisis is not an iron mold like wet concrete, which then becomes hard concrete and you can never change it. We all know that. But head on Smith is the fundamental proposition. Having read this case, I admit on this being in front of this court 100 times. The Smith case, interestingly, is based on a faulty fact. And the fact is that what was going on was the open courts provision Justice Flaherty was reading. This takes a little bit, but I hope not to overstay my welcome on this one issue. He was looking at the open courts provision in the context of its enactment, and there was, and he was looking at Article 3, Section 18 in the same way. And he looks at Article 3, Section 18, and he is, which of course is this no caps provision, which is just, to me, this court has said a million times, you have to look at the clear, unambiguous language of a constitutional provision. He says, well, and by the way, I kind of recognize what he was trying to accomplish. But by the way, he joined the dissent of Justice Larson just a few years earlier, and that dissent is a powerful statement, pardon me for saying so, as to why I'm right and they're wrong. And Justice Flaherty, the majority holder, he signed on to that. But his faulty premise was that the anti-caps provision, the legislature wasn't thinking about the Commonwealth because and therefore political subdivisions, because it had already been determined, there already was judicial immunity in the Commonwealth. It's there. It's in that opinion. You'll see it. And that's wrong, because the history, which we lay out in our brief, and which I recommend to the court, the history of this has clearly been that, but for, ironically, the 36 years which I've been practicing law, beginning in 1978, when the Commonwealth decided, oh, Kline's coming to the bar, we're going to pass this this provision. The law was not immunity. The law was clearly some things you could sue a governmental entity for, some you could not. And the history was that the Justice Flaherty was citing was that at the time of the Constitution, this provision, 1874, I believe, that they were thinking about the 1868 Act, which insulated the railroads. And the argument was made, oh, the powerful railroads, this cap was meant to apply to private entities. But if that's what the drafters meant, then they would have said so. They would have said, in no other cases except this provision, in no other cases except the Commonwealth and its political subdivisions. So we're in yes, I tell you, I come here to tell the court today that, and I'm sure Mr. Cozen will tell you today, that there is stare decisis and it's binding. My word, there are 300 pages of briefs to say that. But the fact of the matter is it's wrong. The concept is wrong, the plain language of the Constitution dictates otherwise, and the fundamental premise under which Justice Flaherty decided Smith was unfortunately factually based on a wrong factual premise.
Well, stare decisis has less weight in a constitutional pronouncement than it does in a statutory pronouncement, correct? Because if it's wrong, it should be fixed.
Yes, yes. And
Constitutional pronouncement.
that's right. And that's why we welcome the opportunity to be here to say that it should be fixed. The Constitution, I don't see how one can read the Constitution, the no caps provision of Article 3, Section 11, and come away with any interpretation other than no other cases shall the General Assembly limit the amount to be recovered for injuries. The General Assembly cannot do it. And another thing that I wanted to be able to say today, I want to take this opportunity, is that there are 5 separate gates, constitutional gates, through which this provision, this draconian provision, which rendered a nullity this jury verdict, and it is a nullity, essentially. Sure. And historically, Justice Stevens, you could sue for a non-governmental, so-called proprietary purpose, something which wasn't core, is the way I kind of see it. But the irony and the injustice here is that had the Pennsbury School District, which, by the way, they later did, and which, by the way, most school districts in the Commonwealth do, had they had this bus with a private contractor, there would have been mandated by Pennsylvania code, I cite the code provision in our brief, mandated $5 million of coverage. The same child who is injured in a bus which happens to have had the school district retain the function in-house is limited to 1/10 of the required insurance thing. I mean, talk about a violation of equal protection. Is there anything in the history? Mr. Cozen shaking his head yes, so I assume that he'll tell you what he believes to be the case. I know of nothing definitive, and certainly there was no real thought given to it. Frankly, and in terms of Ayala, where it tells us, where Ayala teaches us, this court teaches us that there's a progression of facts and circumstances. Here you have in school districts which are insured. This school district for $41,000 bought $11 million of insurance coverage. And here we live in an era where busing in big consolidated school districts, this district with a $172 million budget at that time, insure. And the argument, by the way, that the school districts will go broke and all of the things that are there. The interesting thing there is Ayala was decided in 1973 when we had, if I might say, gas lines and the worst stock market, a crash in the history. And this court said in Ayala, these are not considerations. In fact, Ayala goes as far as to say school districts and municipalities can insure against these losses. And by the way, the argument that there is the school district could be sued in a multiple explosion accident, Well, my word, there are many kinds of things which become the bases, frankly, of civil rights claims and are litigated in federal court because the law here is wrong and doesn't allow a negligence claim to be filed in the most fundamental thing under the most fundamental premises allowed by the not only allowed, but declared by the writers of the Pennsylvania Constitution.
Mr. Kline, may I ask you, we've spent a lot of time on Article 1, Section 11, Article 3, Section 18. I have two questions. First is a pure legal one. In your introductory statement, you referenced Article 1, Section 26 in its non-discrimination clause. Is that the basis of equal protection, or do you derive a secondary argument from that?
I believe it's a basis for equal protection, and I believe that this court has seen it that way. This court has kind of jumbled up, and I don't mean that pejoratively, Article 1, that section, to Article 3, Section 32, and this court has said there's no they here. It's this court says that.
I think that's fine, and I think Article 1, Section 26 is a fine basis for equal protection in Pennsylvania. I just wanted to make sure of your argument.
Yes, and it's never been addressed.
And here's what...
In this context.
In Article 1, Section 26 context.
Article 1, Section 26 was never addressed in the Smith and Carroll case.
All right, and I think that's an important point. What I'd like you to do for me before you sit down, because I want to make sure that I understand this and we understand this, is assume arguendo. And I know that you would argue that it's a fundamental constitutional right at stake. But assume arguendo for me that it's a intermediate scrutiny case, an important state interest. And just succinctly tell me the two classes for equal protection analysis and tell me why the discrimination is unconstitutional. I want to make sure I understand that argument.
If it's an intermediate scrutiny case, which is what Smith said it is, it's not a rational basis, even by Smith, then you're weighing the governmental interest of protection of the Treasury versus the right of an individual to recovery for damages fully and completely guaranteed by the Constitution.
Okay.
That's fine.
Okay, thank you, Mr. Kline. We do have extensive briefs in here, but we'll hear from the appellate.
Thank you very much.
Thank you very much for your...
My honor to be here.
You ready to begin, Mr. Cozen?
Just about, Your Honor.
Please do.
Thank you. The court, please. Steve Kozin for the Pennsbury School District. I'd like to talk a little bit about what the law truly is and what it has been, and then answer Mr. Kline's rather interesting, but I think totally spurious arguments. So let me start by saying that I sympathize greatly with Ashley Zauflik and her severe injuries. But my sympathy and regret is no greater than that of this court in 1986, when in Smith versus City of Philadelphia, it was faced with 7 deaths, dozens of severe injuries, and massive property damage in connection with a huge gas explosion in the Bridesburg section of Philadelphia. Though expressing its regret, this court recognized that the framers of the Constitution intended that the legislature have what this court said was complete control over suits against the Commonwealth and its subdivisions. Such complete control under Article 1, Section 11 by the legislature encompassed both the power to abolish totally any right to recover against the Commonwealth and its subdivisions, and the power to limit the recovery on the actions which are permitted. So said this court. So respectfully, here's the bottom line question. Is this court prepared to not only ignore the right of the General Assembly to act under Article 1, Section 11, to determine immunity or not for political subdivisions and the terms and exceptions to that immunity, including limitation of damages, but to also reject the following statements and holdings of the law which it previously pronounced? First, it is not our function to displace a rationally based legislative judgment. It is within the province of the General Assembly to determine the certain immunities to suit and whether or not in its judgment they're needed for the operation of local government. That's the Carroll case. Written by whom? Written by whom? Justice Roberts. The same justice who wrote Ayala, abolishing common law judicially made sovereign immunity, which has zero precedential value on anything we're discussing here today. There was no constitutional challenge in that case, nor could there be. The reaction to Aiello was the passage of the Political Subdivision Tort Claims Act, and in fact the Sovereign Immunity Act was a response to the Maley case, also authored by Justice Roberts, in which he said sovereign immunity as a common law judicially made concept is no longer viable. We're getting rid of it. But we recognize the right of the legislature, said Roberts in Maley. Actually, if you read it, we recognize the right of the legislature to go ahead and give protection to the Commonwealth as it sees fit under Article 1, Section 11.
When you say as sees fit, it's the converse of Justice Higgins' question. So the legislature put a cap of $1.
The legislature could put a cap of $1. The legislature has the absolute, unfettered, unlimited right. This court has said time and time again, and 9 Commonwealth court cases have said, under Article 1, Section 11, it can abolish it completely. So if it's overruled for some reason today, which I hope never happens, for the sake of every municipality and transportation, subdivision, etc., they can abolish it totally. Mr. Kline may get his verdict, but everybody else for the foreseeable future is dead in the water.
Mr. Cousin, you used the word rational a few minutes ago.
Yes.
Use that word again. What was your phrase?
I think what I said was this court held that it was not its function to displace a rationally based legislative judgment.
Rationally based.
And that was, by the way, Justice Roberts.
I understand that, but we know the law, so I've read these cases. We've all read these cases. Rationally based legislative judgment, does that refer to the, so you have a waiver of immunity. Where does the rational assessment come in?
Well, the rational assessment comes in when the legislature, not this court, because you, excuse me.
Of course, we're talking about the rationality of legislation.
This court has many times said, in fact, you said, Justice Saylor, and I think in the Bickard case, and certainly you said it in Driscoll as well. You said, you know, look, whether you're amending the Constitution or you're passing legislation pursuant to a constitutional authority, you have two things. Is there an important governmental interest? Clearly, preservation of the assets of subdivisions. And should that important government interest be balanced against the right of an individual to sue that subdivision? And as long as there is some rational basis for determining that important governmental interest is worthy of protection by the abolition of any suits against it, you can then say anything that they do in terms of dollar amounts of, you know, to answer the question, $1, $5, $5 million is a rationally based decision. In
You're
fact,
saying, in response to the other question, if you allow, under your reading of the remedies provision, the Commonwealth legislatively allows a suit but caps damages at $1, that's rational?
yes, and I'll tell you why. It has the constitutional authority to do that, and I would say that is
The constitutional authority.
that is
to allow the suit.
to me, that would be an absolute, Justice Saylor, that would be an absolute abolition of sovereign immunity or the immunity of a political subdivision to cap it at $1. But when you say, is that rationally based, if they can abolish it totally,
I
they can
understand that.
set any, and that is a rational basis. Here's the issue.
But don't you understand, and I don't want to dwell on this, my question is, I understand your argument, they don't even have to allow the suit. So, Constitution, if they allow the suit, they can cap damages.
And this court has
But
said that.
if they cap damages in an amount of $1 or $10, don't you move into the area of irrationality,
I think,
having allowed the suit?
from my point of view, that might not be rational. However, none of us here are part of the legislature. The legislature will hear from everybody as to what their needs are.
You think somebody's going to come in and testify, you ought to allow us to sue, but only for $1?
No, I don't think
It's not rational.
No, I don't think anybody would come in and say that, Justice Egan.
Well, then why would the legislature say it?
And because the legislature, and looking at the entire risk management situation of those subdivisions, may say, if we abolish it totally, nobody will be able to sue. If we allow a minimal amount, nobody's going to want to sue. It's going to discourage lawsuits. That's a judgment for the legislature, but I'm not here to argue the rationality of $1 versus $100,000.
So it's rational to say, well, we don't want to keep them out altogether. We just want to discourage them.
Yes,
That's rational.
I think that's rational, and I think that's a judgment for the legislature. And in fact, Justice Egan, if you go through the 34 states that have adopted similar caps as we have adopted in Pennsylvania, what you're going to find is in those 34 states, they did a study, just as we did, of the manner in which the school districts and the municipalities budgeted, how they raised taxes, and what their risk profiles were, and whether or not they could get any insurance if they needed it to cover them for not uncapped liabilities, obviously, but for other things.
Does that have something to do with his question?
I think so. Now,
Missed it.
I would say,
Let me ask you this.
Yes.
Let me put it this way. My son comes to me and wants to borrow the car. I can tell him no, or I can tell him, here are the keys, have a good time. But if I tell him, it's okay, but you got to have it back in 1 minute, is that rational?
I think it's not rational.
Okay.
I think that's not
Is that
rational.
not equivalent to what the question was?
I think-
We're just talking about how many dollars you have to allow when it passes the line of rationality.
Common sense would say that that is not a rational judgment. But that is not what this court is faced with. What this court is faced with is very clear language from this court that says it is inherent within the right of the General Assembly to abolish completely the sovereign immunity, to abolish completely any right to sue a political subdivision. And within that right, to then set whatever limits they want to set.
Okay, look.
Now, you can argue about rationality, but
don't
that's
wanna-
not this one.
I don't want to argue it anymore.
Sure.
The dollar is not rational.
I think that's fair.
And guess who wins those arguments?
Yeah.
Us. I would like you to, though, the question, the distinction was drawn in your opponent's argument between the Commonwealth and political subdivisions.
Well,
Let me ask a question.
sure.
The Constitution speaks in the clause that was under discussion to the Commonwealth and not to political subdivisions. Could you tell me why it applies to a school district as opposed to the Commonwealth?
Yes, certainly.
Thank you.
Justice Roberts in Carroll at 496 PA held as follows. Surely the legislature's authority to choose cases in which the Commonwealth should be immune encompasses political subdivisions. It is axiomatic that municipal corporations are agents of the state invested with certain subordinate governmental functions for reasons of convenience and public policy. They are created, governed, and to the extent of their powers determined by the legislature and subject to change, repeal, or total abolition at its will. So what we have is the same person who authored Aiella taking into consideration whether or not the act which followed Aiello in order to reestablish immunity was constitutional. It was against political subdivisions, the same kind of political subdivision that Aiella sued when his arm was amputated in the school district. And he says, and I believe he is correct, that surely the legislature's authority to choose cases with respect to the Commonwealth immunity encompasses political subdivisions because it's axiomatic that municipal corporations, which are agencies of the state or any other state agency, is the Commonwealth, is acting as the Commonwealth. So I think we have a very well-reasoned opinion in Carroll by Justice Roberts that establishes that the individual townships, municipalities, counties, school districts are the Commonwealth and were intended to be within the Commonwealth definition for the purposes of the Political Subdivision Tort Claims Act.
Mr. Cozen?
Yes.
I'm sorry, did you finish your answer?
No, I think I did. I hope I did. Did I finish my answer, Justice Eakin?
I have no idea.
You finish it.
May I ask you a couple questions, sir?
Sure.
First of all, you mentioned in your extensive answers, excellent answers, that there's obviously, I think was your word, an important governmental interest in the protection of these governmental funds. But it's been established, and I think you were in agreement through a head nod, that the Pennsylvania Code mandates a $5 million insurance policy if the school bus is done by a private contractor. So where's the governmental interest at all in an equal protection analysis so long as your client has $11 million of insurance out there that taxpayers paid for and can't even be accessed?
Well, it is accessed. It's accessed for all kinds of federal claims which cost a lot of money. Discrimination, FELA, copyright infringement, Section 1983 cases. The important thing we have to look at here is what's the function of the court and what's the function of the General Assembly? This is a matter for the legislature. This is a policy decision. The argument, let me walk you.
Let me interrupt you because your time's going to grow short. I want you to direct yourself to an equal protection analysis and explain why the government has an important interest considering its ability to insure.
Yeah, because the government's interest in protecting the assets of the particular political subdivision has to take everything into consideration. If nobody can insure unless they have capped liabilities with respect to a whole raft of tortious conduct that is carved out of the Political Subdivision Tort Claims Act, then nobody can insure. If some people can insure a little bit because they have more money but not enough, and others can insure more, then you have a reverse equal protection issue. Let me tell you, Justice Baer, what exactly the argument is and why it fails. The argument is, well, there's no equal protection when you have insurance. Now, why does it fail? It's been rejected by every single court in the country that has considered it, because the General Assembly knew when they passed the cap what the risk management issues were with respect to each of these political subdivisions and how troublesome it was for them to even obtain insurance for other things that they needed unless they had some capped liability. With uncapped liability, there was neither affordability or availability of insurance to them. That's the legislative history that you were asking about. Secondly, this is an attack on, really, it's a waiver argument which says governmental immunity is waivable because you have insurance. We know that your law has been, you can never waive governmental immunity. Each subdivision has a different risk management scheme. Some have a little insurance, some have a lot, some have less. And that's why the legislature decided in its wisdom, considering all of this, to carve out and create causes of action, but to cap them in order to make available to these political subdivisions some insurance that would be premised by underwriters on the risk that they were undertaking. That's the legislative history. And by the way, and I think this is important, there is no record below, none, no record upon which to make a judicial determination in this regard, Justice Baer. There's no expert testimony and there's no empirical data on any of the classification issues that you were asking about, which I think are totally right on. But this record is devoid of that. You know why it's devoid of that? Because the courts are not the place for this determination to be made. The courts have already stated what the law is. That determination is for the legislature.
Are you in the middle? Go ahead.
Yeah, I want to ask you one more question. Again, I don't want to monopolize it. I recognize time's running short. And,
yes, sir.
But obviously an important case, well-argued case. There's an interesting dichotomy here. Mr. Kline says he recognizes Carroll and Smith and what they say, and he says they're wrong, and so ignore stare decisis. You argue almost exclusively from them, hoping stare decisis holds and saying that they're correct. But when I read them, I read the Papadakis dissent in Smith, which quoted Justice Mandarino. I'm a fan of Justice Mandarino.
So am I.
And Justice Mandarino, in the Papadakis dissent, said, how can the Declaration of Rights, comprised of 26 sections, and I actually think it's 28 sections, but he said 26 sections, all of them withholding rights from the state, somehow have one sentence, the second sentence of Article 1, Section 11, be inconsistent and give rights to the state? How can that be right? And before you sit down, I wanted your thoughts on that. How can that one sentence in these 26, 28 separate paragraphs withholding rights from the state somehow be construed to give rights to the states?
A majority of the justices of the Supreme Court, this court, looking at that very question in Carroll, in Maley, because Ayala has no precedential value here, none, zero. Didn't deal with any of our issues. In Maley, in Smith, in Carroll, in subsequent cases, Tulowitz, and 9 cases in the Commonwealth Court, everybody looked at that provision and they said, the legislature decided when they proposed the Constitution, the framers, they decided by that second section that when it came to the Commonwealth, the legislature would have complete control. They could determine whether there would be any causes of action or none whatsoever, and inherent in that was their determination to give some and to limit them. And so I think that they were right. I think the legislative history demonstrates that they were right, and I can simply say also, with respect to Article 3, Section 18, you haven't asked any questions about that, but I'll stick with what this court said.
We have another question, so.
Yeah, sure. I thought Justice Larson.
One quick question.
Yes, sir.
Would you consider this fair or a fundamental unfairness? Cap in 1980 is $500,000. Somebody sues in 1981, gets $500,000. The cap remains at $500,000 in 2014. They're not the same dollars in 1980. Is that fair?
I think that's a fair, I think that's absolutely fair. But for our purposes today, may I suggest very respectfully, Justice Stevens, that that's not a question for this court. That's a question for the legislature. If the dollar's worth something different today than it was worth then go to the legislature, build the record, and convince the legislature that, the cap should be larger.
I understand that, but as it affects people today, isn't that fundamentally unfair? But I'm done, thank you, that's fine.
I do not think it is fundamentally unfair in the legal sense. You may consider in an individual case that it's unfair, but an individual case doesn't govern the day. What governs the day is the law and the ability of the plaintiff and similarly situated plaintiffs to go to the legislature and make their case and create a record to support it.
You've made your point on that several times.
Thank you.
So we will.
Thank you very much.
This particular matter, we have 12 different amicus briefs, so that the issues are pretty well framed. They're from governmental agencies, transportation agencies, insurance agencies, trial lawyers. So we will take this matter under advisement and we will decide it accordingly. Thank you both for your presentation.